Hello! Datu Puti versus Rajah Puro. The soy sauce battle. Stay tuned. If you enjoyed this video or learned something from it, please do me a favor and click that like button. It will help me help the channel grow. And if you have not yet, please hit that subscribe button on this corner. Again, this helps me a lot and I would truly appreciate it. Welcome back. Recently, in this second week of July 2024, in the news for intellectual property, a company, NutriAsia, sued Dali grocery stores for selling, as far as they're concerned, products that infringe on their trademark, copyright, and it was unfair competition. Now, those are three separate actions, and as a trademark and intellectual property lawyer, I'd like to put on my views on this case. Now, don't get me wrong. I am an intellectual property lawyer, and I am for the protection of those intellectual property rights. I represent photographers, musicians, artists, and other companies in their enforcement and protection of their own IP, their own work that they created. Now, this is a unique case because it presents a unique attack on what is a trademark infringement, unfair competition, and copyright infringement. Let's take the first case, trademark infringement. Now, I did some research, and Datu Puti and Rajah Puro have their individual registered trademarks. So, in a sense, or you can say technically, Rajah Puro as a brand name is not infringing on Datu Puti as a trademark. Why? These are two distinct names, and I don't think any common man will think those are the same. You can clearly see the difference between Rajah Puro and Datu Puti. Now, let's go back. Is it trademark infringement? Now, trademark infringement could include selling off a product that's a knockoff or a colorable imitation of the first trademark. So let's say the first trademark is Datu Puti. Is the label Rajah Puro infringing on the trademark? Well, look at these two images. As you can see from the pictures, there's a distinct literary difference. Datu Puti can never be confused with Rajah Puro. Now, I looked at the trademark of Datu Puti. Aside from the Datu Puti trademark, which they have, it appears that they tried to claim the color red and yellow as part of their trademark. Now, generally, under the trademark laws of the Philippines, color cannot be trademark. I mean, it cannot be registered as a brand name or a trademark of a company, unless it has what they call secondary meaning. I will get into that later. Now, as you can see, if it's not the name, what else part of the trademark are they fighting about? Is it the color? Is it the shape of the square? Is it the shape of how soy sauce is written? That is up for the courts to decide. I just have to give my opinion on it. Secondly, is it unfair competition? Now, to be unfair competition, there must be an intent to defraud, there must be an intent to deceive the buying public. There's a standing Supreme Court case, it's called the Levi-Strauss Doctrine. As far as criminal trademark infringement is concerned, there must be an intent to deceive, or there must be, in the case, a pre-sale confusion. Meaning, Rajah Puro, to be guilty of unfair competition, the Supreme Court said there must be an intent, there must be a drive, there must be a focus to confuse the buying public into thinking that what they're buying was Datu Puti when in fact it was Rajah Puro. That is subjective, that is based on other factors. In the Supreme Court case, some of the factors must include the age, the education of the buyer, the nature and the cost of the item, this being soy sauce, whether the article, the soy sauce, is made for immediate consumption, well, let's say that it is, and also the conditions under it was purchased. Now, Dali Grocery Store, everybody knows it's a worldwide, well, it's based in Europe, and their marketing strategy is to give or to offer affordable products to its customers, meaning cheaper versions, more affordable versions of that product. In this sense, a cheaper version of soy sauce. It is accepted that Dali Grocery Store is offering what they call generic or their own brand of products. So meaning when a customer goes to Dali grocery store, they know they are not buying the top brand of that said product. When they're going there, they need to buy a more affordable, a cheaper version of the soy sauce. Datu Puti, let's say, is more expensive than Rajah Puro. I believe that these customers will know they are not buying Datu Puti. Therefore, what Dali grocery store is doing is not really deceiving the public, the buying public, but giving a better alternative, a better option, a cheaper choice for that same soy sauce. Secondly, it cannot be unfair competition because there was no intent to deceive. Why? Rajah Puro has its own trademark as Datu Puti. So if they're selling Rajah Puro as soy sauce, they're not violating any law because they have their own trademark registration for Rajah Puro. Therefore, who are they violating? They're using their own registered trademark. In this sense, it shows that Rajah Puro did not have bad faith, or rather, they had the good faith belief that they're selling their own product with their registered trademark. Let's touch the copyright infringement. Now, there is some train of thought, there are some scholars, some intellectual property experts saying that you cannot combine both the trademark and the copyright causes of action over the same product. You have to choose or file it separately in separate courts. Then again, it will be combined. Once it's combined or consolidated, then it cannot be. It cannot be together. You are using different causes of action, different defenses, different allegations to support. Why? Copyright infringement is two competing literary works, the first one and the second one. So let's pretend Datu Puti is the first and Rajah Puro is the second. Is Datu Puti a literary artistic work? I don't think so. It's soy sauce. Are they selling the label as an artistic work? No, because it's not sold as a painting or a photo or as artwork. It's sold as soy sauce. You are not selling the label. You are selling the soy sauce in the bottle. Therefore, when Rajah Puro, let's say they are infringing on the artwork of the Datu Puti label, again, it's not being sold as a literary or artistic work. It's sold as a bottle of soy sauce. Thus, in my view, you cannot say it's copyright infringement because it's not sold as a literary or artistic work. There may be some difference in opinion on that, but that's my point of view, and those are some of the cases where you have to choose your cause of action. Now, let's go back again to the trademark infringement with regards to the mark both of Datu Puti and Rajah Puro based on other factors other than the name. Let's say it's color. As you can see, Datu Puti is red, Datu Puti soy sauce, and so is Rajah Puro. To claim that red is associated with Datu Puti is a bit stretched, elongated. Why? Growing up, and some of you who are maybe Gen X, as far as let's say Gen Y, when we say Datu Puti, we all know, most of us, the buying public, know Datu Puti as white vinegar, not soy sauce. Secondly, when we see Datu Puti as a label, we don't see red, we see green. Thus, my point of view is that red cannot have the secondary meaning or the association that it's Datu Puti because the original red soy sauce is Silver Swan. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.